Thursday Club, and this is continuous professional development. Can I welcome regular people that join us, and obviously anyone new coming for the first time. This all supports your CPD requirements, which you know are not only a QSI requirement, but other professional body requirements. We're delighted today to have our Global Board member, Keith Blizzard, who will be giving a presentation on the industry challenge, disagreements and their resolution. And we're looking forward to hearing from Keith. So Keith, as and when you're ready, over to you, please. And are we okay to record this for those that can't attend?
Yes, that's fine.
And if you could kindly mute your sort of cells on, that would be really appreciated. Okay, Keith, over to you.
Thank you. Good morning, everybody.
Sorry, could you mute your? Excuse me. Could you mute your microphones, please? What to speak? MGC. Could you kindly mute your microphone, please? Thank you.
Right, thank you. Good morning, everybody. Obviously, my name is Keith Blizzard. My primary profession is I'm a chartered quantity surveyor. I'm also a chartered construction manager and arbitrator. I'm a panel adjudicator, commercial mediator. I'm dispute board member, forensic surveyor, and I'm visiting lecturer at a number of universities. The purpose of this talk is to put into perspective the challenge that we in the construction industry face on a daily basis. Now, QSI was the main sponsor of an annual conference, which is Construction in the 21st Century. And last September, it was held in Rio. It's a conference where academics come and talk about the results of their research or the research they're undertaking. And a team of us from QSI as the main sponsors, we went out to Rio de Janeiro. I was asked if I would give the keynote address, which is opening the conference on the first morning. You give the first talk. Now, because it's a global conference, people from around the world, I had to think of a topic which would be universally understood and accepted, and also fairly neutral. So I came up with the idea of talking about the structure of the industry and why it is so disputatious. Why do we have so many disputes in the industry? And this is what I came up with. Now, through social media, it's been picked up on. And since I came back to the UK, or since we all came back, since last September, a number of people have asked me to go and give this talk again. So it really does seem to resonate with people across the world, actually. So hopefully you'll enjoy the talk and learn something from it. So the purpose is to give a perspective on the challenge we face in the industry on a daily basis, to explain how the structure in the industry inevitably leads to disagreements. Now, I specifically use the word disagreement to avoid using the word dispute, because everyone has their own views on the meaning of the word dispute. The dictionary definitions are: disagreement is people do not have the same opinion, and dispute is people engage in argument or debate. And also I want to do is set out the means to resolve those disagreements before they become formal disputes, i.e. a dispute requiring an independent third party to make a decision, which is then imposed upon the parties. So it's taking it out of the forum of the people who actually have to make the decision, and you're transferring the decision to an independent person. And then finally, to give you some thoughts that you can keep to help you put into context the complexities of the industry in which we all work. What I'm going to consider is the structure of the construction industry, how it all fits together. The inevitability of disagreements, they're bound to happen. The forms of informal dispute resolution or disagreement resolution, and then the forms of formal dispute resolution, just to close it off. Now, the structure of the construction industry. As an industry worldwide, we do little to publicise what we do. Buildings are complex and often very innovative, particularly going to conferences like CITC, you realise just how complicated and how much research, academic research, is being undertaken. Within a building, there are a number of specialist elements within the overall design. For example, the mechanical, the electrical services, the plumbing services, cladding, the structure, the finishings, the cladding, which has obviously been highlighted over recent years following the Grenfell disaster. So therefore, there are a number of specialist elements that require expertise to design each of those specialist elements. So while you've got these specialist elements, you need specific expertise in that element to design that element. Cladding, you need structural engineers to do the frame and the structure, the foundations, that sort of thing. And the ones I example there are cladding, mechanical services, electrical services, because they're the obvious and most common ones. Once designed, those specialist elements also require expertise to construct each of them, because it's no good having a specialist design and then you put people to actually put that design together and build it who don't understand the requirements. Now, there are many specialists in the design of elements of the building and in the construction of those elements of the building. Both the design and the construction of a project are broken down into much smaller elements of the whole project. The overall design has to be coordinated to incorporate the many specialists. And the overall construction program has to be coordinated to incorporate the many specialists. Each element has its own requirements and limitations, and each may have their own regulations and or requirements. And again, the obvious one is in the UK is for cladding. It's a specialist design and it's now got specialist regulations. But if you think of mechanical services, they have regulations. The electrical services certainly have their own regulations. The regulations may not align, so causing people to have different opinions and therefore disagreements. Disagreements, remember, people having different opinions. In our world, the world of construction industry, the client wants a completed building. Now, in my experience, I had a QS practice. I tend to spend most of my time nowadays sitting as arbitrator and adjudicator, deciding construction disputes, and I said I'm also a commercial mediator. And I spend a lot of time advising clients when things go wrong. But when we had a QS practice, it was our experience that clients may take years, sometimes, certainly a long period of time, to make the decision to invest in a new building or to spend the money on refurbing a building or altering a building. And they spend quite a long time going through all that. And then once they've made the decision, they now want the building because they've taken ages to make the decision. Now they want the building. So the pressure's on to get it built. And I think one of the hardest problems I had as a project manager was getting the clients to slow down. We did a European headquarters building for a company, and they'd spent literally years trying to work out where they were going to put it, which country, and then not only once they defined the country, whereabouts in the country, then they had to find a piece of land. So by the time we first got involved in producing designs and a building, the project was over 2 years old as far as they were concerned. So it's old hat to them. So, well, we've taken a long time to make this decision. We now want the building. The client may decide or be advised to separate the design from the construction. And in that particular case, that is what we did. We said to the client, right, you've got very specific requirements. What are they? And they were ever changing. How many offices they needed, who was going to have what what facilities they needed, conference rooms, all this, that sort of thing. And that was the problem which we and the architect had, drawing it out of the client. It's a very common problem, drawing out of the client exactly what it is that they want to end up with. Because all they knew is they wanted a European headquarters building, and it's got to be, look, you know, spectacular because they're a big and important company. But they had to slow down. We said, right, well, okay, if your requirements keep changing, there's no point in going design and build because it gets very expensive if you're going to change the design. What you need to do is have your own design team. Then they design the building that you want, and all the decisions and all the changes can be made before the contractor gets involved. Alternatively, the client may decide to have one line of responsibility and require the design and construction both to be one company, the design and build, or D&B as it's known. And we had an extension to a factory unit, which was doubling the size of the factory unit. And there, the easiest thing was design and build, because they wanted it quickly. And it was pretty straightforward. It's just extending a big shed with more big shed. So we could go design and build. Whichever route is decided by the client, there are many individual commercial contracts. In the case of the building, in case of the European headquarters, there was contracts with us as the project manager, us as the QSs, the architect, the mechanical services, electrical services, landscape architect. I mean, the architect for the overall design of the building as well. So there were lots of individual contracts. And with the design and build, then there'll be a contracts with the designer, perhaps, of these, again, structural engineering, services, all the other people. So with the various designers of the relevant specialist elements and with the various contractors who build those relevant specialist elements, because I'm thinking here not just between the employer and the main contractor, but the main contractor and the subcontractors. That's right. Got somebody else who's not muted.
Sorry to interrupt, Keith. Could I ask everyone to mute their microphones, please, so the speaker can continue?
Thank you. So whichever route is decided by the client, there are many individual commercial contracts with the various designers and then with the various contractors who build those relevant specialist elements. And I'll give you another example. There was a building in the Midlands, and it was it was design and build, and the main contract, the architect had come up with part of the employer's requirements. He wanted a building. It was 10 stories high, and it was going to be have the external cladding was going to be glass. But what he wanted to do is have the building clad in glass, but then he wanted to make it look like it was brick built. So he wanted concrete panels with brick slips on. And they fell out with the first. They got the cladding contractor involved early on, the subcontractor involved early on, and then they fell out. And then there was a second cladding subcontractor. And in the end, they had a dispute with the main contractor as well. And I was the adjudicator. That's why I know the story of this. In their first meeting, the main contractor explained what the architect's design was, clad it in glass, and then put these units on the outside. And the specialist cladding contractor said, well, how big are these units? What do they weigh? And they said about 11 tons. And the specialist subcontractor then said, are you mad? You want us to fully glaze a building and then lift 11-ton concrete units 10 stories high and then fix them onto the outside of the glass? Never mind how we're supposed to fix them to the outside of the glass. It's completely and utterly uninsurable, because any breeze, and you can be on the ground and have no wind at all, but any breeze you get 10 stories up, that thing starts swinging, it will simply smash the glass. Why don't you put the cladding panels on first and then we glaze in between them? Which seemed to be a sensible idea. And in fact, that's what they agreed to do in the end, because the architect knew what he wanted the building to look like. but it was the best way to actually achieve the look that he wanted. Now, coordination of various specialist designers with their separate requirements may lead to disagreements. When I was a young QS, I always said that the first time a job ever got built was when the quantity surveyor produced the bill of quantities. And I was doing an office block, and I'd got the architect's design, and then I got the structural engineer's frame. And I started measuring the concrete frame. And I realized that from a structural engineer, the structural engineer had designed the beams which were narrow but quite deep, which I'm assured, I don't know, I'm not a structural engineer, but I'm assured that is the most efficient structural way of designing beams. The problem was the depth of the beams came so low, they were lower than the height of the ceiling. So instead of having a flat horizontal suspended ceiling, you got ceiling in panels between the concrete beams. So I asked the architect, is that what you want? Do you want a flat surface, or do you want the beams to be hidden? And he said, well, no, I need the beams to be hidden. I want a suspended ceiling with a flat surface. So there was a disagreement. The structural engineer had done the most efficient structural design, and the architect had a different concept for the look of the building. It wasn't a dispute, it was just simply a disagreement. So the structural engineer was asked to redesign the frames, and in those days it was with even in those days it was computerized software. They just put in different parameters and got a different design. Then when I was went back to measure the frame again, I realized that what they'd done is he told the architect had told the structural engineer how deep the beams could be, i.e. the difference between the underside of the floor to ceiling height, if you like, and which meant then that the beams came to just above the height of the suspended ceiling. So the suspended ceiling framework could go below the beams. And that was no good either, because then the mechanical services engineer said, well, hang on, we've got to get the ductwork in. I need cable trays. They've all got to be hidden above the suspended ceiling. So in fact, I need the beams even shallower, less deep. So they've got to be wider again. So the structural engineer kept redesigning the beams until eventually they could accommodate the difference between the depth at the bottom of the beams and the top of the suspended ceiling would accommodate the cable trays and the mechanical services, the air conditioning ductwork. Now, obviously, with BIM, that is much better coordinated nowadays. But it was a disagreement because they looked at it from their own regulatory point of view, the most efficient design point of view, and the architect had the overall concept of what the client wanted, and the architect wanted the building to actually look like. So the coordination of the various specialist subcontractors may lead to disagreement because you've got the designers, but then you've also got the specialist subcontractors. The coordination of the various specialist designers with the various specialist subcontractors may lead to disagreements. So what I want to explain here is that you've got disagreements at the same level of designer. You may have disagreements between the designers and the subcontractors, the specialist designers and the specialist subcontractors, but you also may then have disputes during the construction phase between the different subcontractors as to what goes in when and who has to go in first. There's no point, for example, there's no point in putting the suspended ceilings up or even the suspended ceiling framework up before you've got the ductwork in and the cable trays. So therefore, the structure of the construction industry will inevitably lead to disagreements, as only each specialist designer or contractor has the full information and understands the full implications of the constraints upon it. And we've not looked yet at any form of payment. This is not disputes about payment. This is disputes about the design, coordinating the design and coordinating the construction. So considering the main contractor, he was employed to coordinate the whole construction. The company's return is based upon the difference between the amount it is paid by the client and the amount it has to pay to its subcontractors and its own costs in running the project. because that's the profit. They've got to make a profit. To the main contractor, the success of a project is dependent on the return it makes, because if you're not making a profit, you're going to go bust. And on other outcomes, including client satisfaction and the prestige of the project, leading to further work and enhancing its reputation. So from a main contractors, from their point of view, a successful project is one that makes a return, the return that's required, and they also have to take into account the client satisfaction, because that may mean repeat work, and the prestige of the project, which may lead to further work and enhancing the reputation. Ah, yes, they did, that company did that building, therefore I want them to do work on our building. And it's the way people select contractors to tender or even negotiate contracts with. Considering each of the subcontractors employed to build its element of the whole construction. And each subcontractor's return, again, is based upon the difference between the amount it is paid by the main contractor and the amount it has to pay to any subcontractors. Well, they're subcontractors, aren't they? And its own cost in running the whole project. For example, you have, let's take steelwork, because that's an easy one. You have a steelwork subcontractor. They may well do the design as a specialist subcontractor. That's got to meet all the requirements and comply with the regulation. They have got their own regulations, how big the steel is. And interestingly, because my brother-in-law was actually the technical director for a steelwork subcontractor. And many years ago when he was a student, and I was a student too, he actually designed, he worked for a steelwork subcontractor, and he designed a portal frame. And there was nothing wrong with the design, but they got a phone call one lunchtime to say the portal frame that they just constructed had collapsed. Now, this became a bit of it was obviously a major problem for the subcontractor as well, but it was all written up in the New Civil Engineer magazine. Because what had happened was they, as a steelwork subcontractor, they had certain safety factors which they had to adhere to. So they multiply up, they work out loads, they multiply it by the safety factor, and then they use that as the basis of the design. Now, if you're a consultant, an independent consultant steelwork designer, you take this factor of safety and you add a bit on. And then, because you don't want to have any PI insurance claims, so what you do is you make it even stronger. And therefore, the cost goes up. If you're a steelwork subcontractor, including doing the design, then you can't do that, because if you do, you'll be the highest price, and therefore you'll not be competitive. So what my brother-in-law had done is he designed strictly to the book, using all the correct safety factors. On investigation, because you can imagine he was fairly concerned, and the managing director said, right, you and I sit down and we go through your calculations now, and somebody else is going to go up and have a look at the site. Anyway, cut a long story short, eventually with the investigation, they found that what had happened is all the insulation to go on the roof had arrived just before lunch. And so they unloaded it and put it all in one corner of the whole portal frame. And that frame was never designed to take all that loading in one place as a dead load. And therefore the frame collapsed. So there was nothing wrong with the design. It was simply in the way that on site they carried out the construction process. The frame had gone up, the frame was perfectly correct, but it was just the loading, because of the insulation, should never have been unloaded and left, excuse me, should never have been put in one corner and then left, because it didn't collapse straight away. It was that weight over a period of time while they were having lunch that it caused the collapse. Now, each subcontractor's return is based on the difference between the amount it's paid by the main contractor and the amount it has to pay to any subcontractors. And again, steelwork subcontractors, I know there are companies that simply have steel fixers. So the company my brother-in-law worked for was technical director. They would do the design, which he'd oversee. They'd cut the steel and do whatever, but then they'd have a labour-only subcontractor who would actually do the erection process on site. So the main contractor, the amount it has to pay any subcontractors and its own costs in running the whole project. Again, the success of a project as far as the subcontractors are concerned is dependent on the return it makes, but also on the other outcomes, including the client main contractor satisfaction, because if the client's happy and the main contractor's happy, you might get more work, and the prestige of the project. They were the structural engineer, and they built the steelwork for, let's say, the Shard or whichever building, which is known, so it enhances their reputation. With such a fragmented structure, it is inevitable that there will be disagreements between the various parts of the industry involved in such a complex commercial situation. So in relation to the design process, in relation to the construction process, in relation to time as well, and in relation to payment and costs. So what are the forms of informal dispute resolution, informal disagreement resolution? The most economic way to informally resolve any dispute is easy. Communicate. I explained how the communication ran in simple terms with the office building that I was measuring, suspended ceiling and the structure above, and then the mechanical services and electrical services with the in relation to the suspended ceiling. It was simply talking, communicate. So in my experience as a quantity surveyor, project manager and construction manager, and now as an arbitrator, adjudicator and commercial manager, commercial mediator rather, face-to-face communication. And the thing that I really would underline is without emotion is the best way to communicate. So many disputes I see that come before me as an arbitrator and particularly as an adjudicator are when communication's broken down. I've had the situation where they're arguing over costs, and I've ended up having a meeting to understand what the parties are saying. I've had a meeting with the two QSs, and one meeting in particular, the QSs just wanted to argue. They really didn't get on. And I was in the position whereby we were in a room with a big table, and I said to the quantity surveyors, you go back against that wall, you go back against that wall. So they were away from the table. So what's going to happen now is that you can come forward, you can explain your points of view. The other QS can stand where he can see what we're looking at, but he's not allowed to say a word to the other QS. If he has a question, he has to ask through me. And that way, everybody calmed down, and that's the way communication went. But it really was fairly childish for me to have to do that with two experienced quantity surveyors just because they didn't like one another. And quite often it's between the architect or the contract administrator and the main contractor, the contractor's people on site, the directors and the employer don't get on. And therefore communication breaks down, and that is when there's a problem. Face-to-face communication and without emotion, looking at dispassionately, and that's the problem. People get too excited about things and then they don't argue their case in logical ways. They argue it with the emotion, based on the emotion. Telephone or video link can be very efficient. Phone somebody up because you can exchange a lot more information face-to-face. Well, ideally face-to-face, but then over the telephone or video link. And I like video links nowadays, which is commonplace. I mean, we're doing this on through Teams. They're very common. And now as an arbitrator and adjudicator, I often have meetings with the parties and parties representatives over the internet. If I'm holding a meeting where we've got to go through loads of documents, I have a meeting which is face-to-face. But if we're discussing timetable or various things, and particularly with an arbitration, then we can have a sensible conversation and dialogue when they're face-to-face. And also, I don't know about you, but I found that people, when they're face-to-face, can be very polite. However, in emails, they can be fairly rude. So emails or other written communications can also be misunderstood or misinterpreted, because if people are emotional, it's not what's written, it's how they read it, how they perceive it. Now, sometimes that could be on a telephone link or telephone or video link. That could be the intonation of a voice. You can be very aggressive the way you say something, or you can be very passive about the way and conciliatory in the way you say things. And I've seen this as a mediator. It's not necessarily what you say, it's partly how you say it. And with written communications, people read, if they're already, if communications are breaking down, they get an email and it can be quite brief. And it's how that's interpreted and received by the person who's receiving it. Wow, look at this email. How dare they write sort of such a brief email to me? What they really mean, I'm getting really fed up with this person. So it can exacerbate things. I often communicate with the parties by video link, particularly if I have something which they may find disagreeable to hear. Like, for example, in an adjudication, I'm going to have more time. You've spent a lot of time getting these submissions to me. I'm going to have time to read them and consider them. And the reason I do that is because I instantly engage with the other people and I can gauge their reaction. I can see immediately if they've understood the point I am making and see their reaction to it. If their reaction is adverse, I can then follow up my comment to diffuse the situation if necessary. To communicate, explain the issue without emotion and set out your constraints. Regulation, practicality, time, cost. When we had our first QS practice, we did a lot of work for the petrol retail industry. And with the petroleum retail industry, when you're building petrol stations or doing any works on petrol stations, you've got all the building regulations as you'd expect, but there's also the petroleum licensing regulations, which are different because sometimes it's the trading standards, sometimes it's the local fire brigade. And we were working on one particular petrol station in Wales. And there was a regulation that no manhole could be built within a certain distance from the door to the shop. And the site was quite confined, and the shop had been in the same position for years. We were refitting the shop. We were doing alterations to the forecourt, but there was a manhole which we wanted to reuse. And the Petroleum Licensing Authority was the local fire brigade. So we got hold of the local fire brigade officer. He came out and had a look at it, and we said, look, it is 3 inches too short, but it's been here for however many years. And he said, yes, he was happy for us to reuse rather than cause a disruption of breaking up and doing it. That was going to be more dangerous, if you like, cause more concern than if we left it within 3 inches too close. So we carried on. When the job was nearing completion, he'd moved on, and the petroleum licensing officer was somebody new. He came in, measured it, and said, that's 3 inches too close, change it. Now, he had the power to prevent, it was ESSO actually, to prevent ESSO from actually opening the station. So we had to move the manhole cover. So we had to tell ESSO that there's going to be a delay. Now, that was not easy because this was pre-video links. So they weren't going to take this very well. But what we had to do is, in fact, what we did was we got hold of the local engineer, and we actually met him on site to explain. So I could immediately see, I knew what their reaction was going to be. The engineer would understand, and the SO marketing team would not. But anyway, we were then able to speak with he and I, the engineer and I were able to speak to the marketing team and diffuse the situation by just explaining it's not us, it's not the contractor who's late, it is the change in the personnel on the regulation, and they have the power to prevent the station opening, and therefore your choice is either never open the station or accept the delay and we move the manhole. If you explain that it's regulation, practicality, and again, there's a lot of, with all the changes coming around from the Building Safety Act, there's now going to be time delays for people getting approvals for things. If you explain the reasons why you're doing something, as I just explained to you, I meet parties and I say, I need more time. Why do I need more time? Because I can't be bothered to do this, or I've got better things to do. I've got a nicer case, which I'm more interested in than deciding your decision, making the decision on your case. No, you don't do that. And that wouldn't be the case anyway. What you have to explain is why. Well, why is because you've spent the parties have spent a lot of time and therefore money on their representatives putting these papers together, these submissions together. Presumably you want me to have time to read them. And in fact, I've got a live adjudication at the moment, and exactly that has happened. I've now got 26 lever arch files. And I've said, it's going to take me time to read all this lot. Anyway, if people can understand your point of view, it takes the emotion out of it. Once you've explained your point of view, listen so that you can understand their point of view. You have one mouth and two ears, use them in those proportions. You can explain your position, but the important thing is to do informally resolve disagreements or disputes, state your case with reasons, without emotion, and then listen to what they say, hopefully explaining their position without emotion as well. So there's a reason why construction contracts are written to include a contractual requirement for cooperation. It empowers one party to remind another party that it agreed to cooperate from the outset. So often it's not what you say, but how you say it. And so if there's a disagreement and they're being unreasonable, you can remind them, well, hang on a minute. The contract says you undertook to deal with us on a cooperative manner. We're trying to cooperate with you. Can you please cooperate with us? Construction contracts are also often written to include disagreement escalation provisions. If a problem is not resolved by the people immediately involved, it can be passed up through the management chain so more senior people can hopefully resolve the issue. We had a client who was having some student accommodation built, and the directors of the development company and the regional directors of the contracting company kept meeting in coffee shops in London and having storming rows because the contractor was late. At the end of the job, I won't go through all the details. At the end of the job, I was involved by the developer, and he said, "What's going wrong? We can't get this, and we've got to get to a final account, and this is now what can we do to get them to speed up?" Anyway, at the end of the job was finished, and I'd said to the developer that I think I'd understood what was actually happening, which was the guys on site didn't have another job to go to, and this was at times of recession. So what they were doing was they were telling they weren't finishing the job in a logical way. You've got multi-story flats, student accommodation, and you'd normally have a finishing team on each floor or every other floor, and then they work their way from one side to the other, and then move to the next floor, and then the next floor, and then the next floor. What they were doing was actually doing just random rooms and finishing those off, which made no sense at all. They were telling the developer that was because the directors wouldn't give them the resources to actually do it the logical way. They were telling the directors of the contracting company, who were also saying, why don't you do this logically and just run through floor by floor in the normal way? You can then close off a floor. And they said, no, the developer keeps saying, do this room, do that room, do the other. In other words, they were telling porkies. But basically what they were doing was they were playing the two sets of directors off against one another. I explained this is what I thought was happening to the developer. When the job finished, the developer had a meeting with the directors. They explained to the directors with whom they'd had all these rows. They had a meeting with the directors and said, this is what we think's happened. You've been told one thing, we've been told the other, and they've run the job because they had no other job to get to. So they were agency people as well, the guys on site. So they were managing the project to suit themselves, which didn't suit the contractor or the developer. And the developer then said, right, this is what we think the final account is. That's it. Take it or leave it. We want the final account agreed so that we know how much we're spending. We think that's a fair assessment. And then the contractors' directors thought about it, and 2 hours later, having separated and come back, in the meet up again in the same coffee shop, they accepted it. So the whole final account was agreed in the space of about 3 hours by 2 meetings in a coffee shop in London, rather than the costs of having delay experts and everybody else involved. And that's the way you sometimes have the disagreement escalation provisions, because if the guys on site aren't getting on, you take it to somebody else who's a bit more remote from it. They can look at it with less emotion or no emotion and more logically. And eventually you get up to the managing director or a senior director, commercial director, and they will look at it from a point of view is, if we're going to, from the main contractor's point of view, how much have we made? How much have we lost? What are we prepared to settle for? Because we don't want massive legal bills. And only once those systems have been exhausted without resolution is there a dispute. So that's a disagreement leading to a dispute. So what are the forms of formal dispute resolution? If a disagreement cannot be resolved for whatever reason, it may escalate into a formal dispute. Construction contracts set out the various forms of formal dispute resolution that are available to the relevant parties. I'm not going to go through them in detail because I could talk for a day on each one of them. But the most significant and usual are mediation. I suppose the most common is actually adjudication, arbitration, and court proceedings. And it's the cost of those which are really prohibitory for small amounts of money. If you're going to adjudication because you can't get your costs back, you have to have a decent amount, otherwise it's not worth pursuing. Mediation. In mediation, a third party acts as a facilitator to help the parties to resolve their dispute on terms that they can both live with. It's completely private. And I enjoy mediation because it's the one thing I do where people aren't saying, well, what do you think? Mediation is very popular with the government because it keeps disputes out of the court, and the courts cost the government money. It costs the parties money because you've got the fees to pay, which we'll come on to. But it's also a more amicable way. And with mediation, it's completely private. So if a contractor has a dispute on, say the main contractor's got a job that's gone seriously wrong, he may want to mediate with individual subcontractors rather than the whole world knowing that that job's gone completely wrong, and he's end up in court with lots of different, he's got disputes with lots of different subcontractors all on the same job. As a mediator, I'm there simply to understand what the parties' positions are, and then after that to help the parties reach a resolution which they can both live with. I have no emotion involved in this at all. I don't mind what the parties, all I'm trying to do is get them to agree something with which they can both live. I'm not saying who should win, who should lose. I'm not saying what the settlement could be, although there are nowadays, because mediation's evolved so much, sometimes you get evaluative mediation. And if you pre-agree it's an evaluative mediation, then having heard things, if they can't settle, the mediator is asked what he thinks is a reasonable settlement. And that can be helpful, actually. Because what you're trying to do with a mediation is people come into a mediation very firm in their own position. And what you do as a mediator is what's called reality testing, saying, well, actually, if you're wrong and they're right, what would that be? Are you sure about your position? And with this, lawyers can be really helpful or really obstructive. Experts can be really helpful or really obstructive, and the parties can be really helpful or really obstructive. But it's the parties that have to make the decision in the end. And with mediation, it's not just A pays B money. You can also have mediation agreements where they say, right, we will allow you to tender for the next 5 jobs, or we'll carry on working. So there are non-monetary parts to the mediation settlement agreement. Adjudication, this is in some countries, but in the United Kingdom, there's a statutory right to refer a dispute arising under a construction contract to adjudication at any time. There are provisions regarding adjudication can also be written into a contract. They are in all the standard forms of contract now. The dispute is referred to an independent third party who considers the submissions of the parties and makes a decision based upon the terms of the parties' submissions, the terms of their contract, and the applicable law. And sometimes people, party representatives must realise that that is the function of the adjudicator. And sometimes you get parties who represent themselves, and there's far too much emotion in those and very little facts and very little evidence. And if they don't provide the evidence, then they're not going to win. And with an adjudication, you have to win on liability. Yes, they owe us some money, and the quantum, the amount, and you have to prove both. And I had it where I got 2 firms of solicitors, representing each of the parties, and they'd gone absolutely berserk on liability. And when it came to the money, the amount, that was sort of QS-y stuff, and they didn't put any evidence in. Now, because in adjudication, you've got to win on both quantum and liability, and the decision is temporarily binding upon the parties until the same decision is finally decided in arbitration or court, or by agreement of the parties. We're not going to argue anymore. Then what they did was, because they got a win on both, I looked at the submissions and I said, well, actually, you've got hammer and tong on liability. You've given me nothing on quantum. There's no point in me deciding liability, because as far as this adjudication is concerned, you're not going to win anything. And that was my decision. I'm not going to consider things further because you're not going to win anything. So therefore, the answer is you don't win. And it's because as an adjudicator, I'm obviously under an obligation not to waste the party's money and spend time doing things unnecessarily. So that was my decision. It was a fairly brief decision. Because you haven't given me anything on the quantum, you're not going to win on quantum. Therefore, there's no point in me wasting my time looking at liability. As an arbitrator, it would be different. Arbitration, it's an alternative to court proceedings to finally resolve a dispute. An adjudicator's decision is temporarily binding, as I said, until the same dispute, there's no appeal from an adjudicator's decision. It's either enforced or not enforced. And I've had some of my decisions. I mean, I've done over 500 decisions, awards as arbitrator or decisions as adjudicator. And most of I have had a couple of my decisions which the courts didn't enforce, but that was nothing to do with anything I'd done. It was challenges over jurisdiction. And the court decided that I didn't have jurisdiction, and therefore they wouldn't enforce my decision. But that was nothing to do with me. I've never had a decision not enforced because of what I did. But as I say, there's no appeal from an adjudicator's decision. It gets enforced. Now, with arbitration, adjudication is similar in one respect. It's private. I don't tell you who the parties are. There's no public, unless it goes to court. People would not know there had been an adjudication between those two parties on that particular job. Arbitration is an alternative to this because this is a final dispute resolution. You either go to court or you go to arbitration. The parties must agree to refer disputes to arbitration because that excludes court proceedings with some exceptional circumstances. Provisions regarding arbitration have to be written into a contract, or they have to be in writing. So even if you've got an oral contract, which you can adjudicate nowadays on an oral contract, you can arbitrate on an oral contract. But funnily enough, the arbitration agreement has to be in writing. a peculiarity. I arbitrate under an arbitrator in England and Wales. Your powers are derived from a statute, which is the Arbitration Act 1996. The dispute is referred to an independent third party who considers the submissions of the party and makes an award, not a decision, but an award based upon the submissions, the terms of the party's contract, and the applicable law. The award is final and binding on both parties and can only be appealed on a point of law. And then you appeal to the High Court. You ask, but it can only be appealed on a point of law. And then only within 28 days of its publication. Now, as an adjudicator, as soon as I've made my decision, I have to send it to both parties. And then I can send them my bill and hope to get paid. And if you don't get paid, you can sue them and pursue your fees. As an arbitrator, when I publish my award, it's when I sign it. So I publish my award, and then I have what's called a lien over my award. I can hang on to my award. I don't tell the parties the answer until my fees have been paid in full. Now then, you can only appeal an arbitrator's award on a point of law, and that is within 28 days of its publication. And its publication is when I sign it, not when I deliver it to the parties. So let's say I make and publish my award. I write and tell the parties my fee is X pounds. Upon receipt of X pounds, I will then deliver a copy of my award to both parties. If I don't get paid within 28 days, and then get paid on the 29th day or a subsequent date, I then send them my award because I've been paid in full. I have to release my award, send it to both, and they want to appeal my award on a point of law. In that case, they're too late because the 28 days have elapsed, because it's from the publication of the award when I signed it, not when I delivered it to the parties. And finally, you've got court proceedings, which is referred to a judge who considers the submission of the parties and hands down a judgment. The judgment is final and binding upon the parties and can only be appealed on a point of law. The parties are required to have solicitors, often with counsel, barristers, to represent them in the court proceedings, in which legal jurisdiction proceedings can be commenced. Contracts often say that the jurisdiction of it's under English law, the law of England and Wales, because England and Wales are one system. Under the laws of England and Wales, and the courts of England and Wales will be the exclusive court to decide any issues. So that restricts it down. So I'm now going to leave you with one further thought on formal dispute resolution. Two parties had a serious dispute that was very severely affecting their previously long-standing and mutually successful working relationship. In order to avoid prolonging their dispute and distress, and in order to preserve their working relationship going forward, they asked me to decide the issue as an adjudicator. The dispute was over payment for the works that had been carried out, and they both asked me to consider their submissions and decide a value. I was to give them no reasons at all, simply a figure. They didn't want reasons. If that value was more than had been paid, the client agreed to pay the main contractor a further payment. If that value was less than had been paid, any balance would be repaid by the contractor to the employer. And that was one of the nicest adjudications I've done, to be honest, because I just had a meeting. They both said, we've got our view of the final account. Our PQS has got their view of the final account. Can you meet both the QSs and just go through it? And I did. And the meeting lasts for a few hours, and they didn't want any reasons. All they wanted was a number. So I went through both parties' valuations, and I then said, right, you'll have my decision by close of play tomorrow. Because all I had to do, I'd written most of it up. All I had to do then was just put in a figure. And that's how I completed things. So I hope with this talk, I've put into perspective the challenge that we in the construction industry face on a daily basis. I've explained how the structure of the industry inevitably leads to disagreements. I've explained the means to resolve those disagreements before they become formal disputes, by communication largely. I've explained some of the forms of formal dispute resolution by third parties, and I hope the last one as well gives you some thoughts that you can keep that put things into context, put into context the complexities of the industry in which we all work. Thank you very much for your attention. That's all I wanted to say.
Thank you very much, Keith. That was fascinating. Thank you, as always. We have just got literally a couple of minutes left. And there is a question in the chat, I noticed, from Peter. If I can read that out to you, if that's okay.
Yep.
Regarding contractual requirements for collaborative working, such as JCTD&B Article 3, how enforceable are they? And could you have parties disagreeing as to what constitutes collaboration?
Difficult, and yes, because if people are going to disagree, if I can see the chat, it'd probably help me actually.
Want me to read it again, or have you got it?
It's all right. I've got it.
Right at the bottom of the chat.
Regarding contractual collaboration, how enforceable are they? Well, how enforceable? It's interesting because you can raise it in arbitration, adjudication, or in court. But what are the consequences? They haven't been collaborative. They have been unreasonable or vexatious. Well, so what? You've still got to make the decision based upon the party's contract, and the evidence that's given to the decision maker, the judge, the arbitrator, or the adjudicator. The party submissions and the contractual terms and the general law. I don't see that. I think it's nice, and I think that's more to help with the informal dispute resolution or resolving disagreements, because you can remind parties. But once it becomes to a formal dispute resolution, then I think it gets a lot more difficult. And the fact that these provisions are in, the courts have made a decision actually regarding adjudication, because what people have said, and I know it's been argued before me, that, well, hang on a minute, the regional directors are supposed to meet and sort this out, and they haven't. We've gone straight to adjudication. Well, under English law, the law of England and Wales, also Scotland and Northern Ireland, then you have a statutory right to go to adjudication at any time. So even if you haven't followed those procedures, you can go to adjudication. So it's rather difficult. Could you have parties disagreeing as to what constitutes collaboration? Yes, you can. Because if parties are going to disagree, then they can disagree over anything. And sometimes, I mean, NEC contracts have been collaborative. One of the main points of NEC contracts is that the parties do collaborate and work together. And I think that NEC disputes, once they get to someone like me, they're a bit like a divorce. Married couples or partnerships, whoever, if you're in a relationship, you will take more grief from the other person than anybody else. And but once it comes to separating or divorce, and I used to be a partner in a law firm, and we sat next to the family team, so I've understood and heard a lot of things that can happen in divorces. Once it gets to divorce, then it's absolute war, and the parties, there's some stresses between the two parties, but then once that link breaks, they go miles apart and they take opposite positions to fight. And that's what happens with NEC contracts. I mentioned the two QSs who didn't get on in the meeting, and that was under an NEC subcontract actually. But yes, once they get to the position where they don't agree on anything, time of day, and it is like a divorce, and it's all out war. Any other questions?
Thank you, Keith. It is actually gone 9 o'clock now, so unless anybody has a burning question they want to ask, I think we should probably draw it to a close. So as always, thank you, Keith. That was excellent. Thank you all for attending. Our next Thursday CPD, which will be on the 1st of May, will be on the UK New Procurement Act, which has just come into force earlier this year. So details of that will be coming out on the email probably early next week. So you'll all see that and get a chance to reserve your spot. If anyone wants a CPD certificate or a copy of Keith's slides, then as always, pop a quick message in the chat now or drop me an email at any time and I can sort that out for you. So again, thank you all for joining us. Have a lovely day, and particularly thank you, Keith, for a really interesting presentation. See you all soon.
It's been fun.
Thank you.
Take care.
Bye-bye.
Bye-bye, everybody. Bye.
Bye. Bye.
Right.